So good evening, everyone. Welcome back to this webinar series. This will be the third episode, the fourth episode overall, and the third part of the individual bankruptcy that we have been talking about. We have so far discussed about how the creditors constitute the committee, how this process is different from the process that we have for companies and the liquidation, what would be the terms of the various the periods, the final the final status of the bankrupt after the whole process. We have briefly talked about all that. Over to Anil sir to take it forward, and hopefully, and we will see in case today the time permits for us to complete it. We'll try and do that.
Thank you, Ankit. Good afternoon to all the participants. It is really a wonderful experience. Today, we are having this fourth episode of this series, and we wish to continue this way. Instead of Sunday, this time we did it on Saturday because Sunday, because of the family function, we were not available. So Saturday, but otherwise every Sunday between 4 to 5, and we are not going to extend. If the subject is not complete, we will make another part. But the intent is that it should be a complete education. It should be a complete understanding. And also we would like to answer all the questions in between. So the format would be the same. Ankit would interact with all of you to understand your questions. He will speak out your questions with your name, and we will try to answer. Bankruptcy as such is a very, very important subject. We have in the first part, we dealt with the importance of moratorium in bankruptcy, although that's being misused. As I said, anyone who has been proceeded against by banks or financial institutions, and anyone who is starting the enforcement, I have seen the personal and the individuals, they have started filing applications for their insolvency resolution process so that they get moratorium, and then they get time to settle all the dues with the banks or financial institutions. In the second part, we talked about all the disqualifications and restrictions on the bankruptcy, and then we also spoke about the claims. We stopped at one important, very, very important part of the bankruptcy, that is the discharge order under section 138. We have seen there are two kinds of discharge orders. One is the discharge order under section 119, which is regarding the, which is after the insolvency resolution process is successfully completed. And the second discharge order is under section 138, where the bankruptcy is going on. But the very important part that I'm going to tell you today is what exactly is a discharge order under the bankruptcy part. So I'm just trying to share my screen with you. So we, in fact, I hope it is visible, Ankit, the screen is visible.
You can just make it full screen.
Yes. So the one part of the bankruptcy is to the administration and distribution of estate of bankrupt. That's it is the duty of the. So now in this conversation we will use this word BT for bankruptcy trustee, because this may save some time. It is the duty of the BT to conduct administration and distribution of assets of the bankrupt, and then the BT will convene committee of creditors meeting for completion of the administration and distribution of estate. The BT shall provide a report in the meeting, and the COC will approve the report within 7 days from the receipt and will determine if the BT be released under section 148. So the BT only would be released much later after the administration and distribution of the estate of the bankruptcy. So let's try to understand again. First part is the insolvency resolution process of individual who has given any bank guarantee to any loan to a corporate debtor. That's the first process, which itself will take about maybe a year or more. I still feel that it will take more than a year. It will take 1.5 years. And thereafter, the bankruptcy application will be filed. And after the bankruptcy application is filed, the first part is the BT will be appointed, and the BT will start taking the claims, verification of the claims, will start making the estimates of the assets and liabilities of the bankrupt, and then the bankrupt would be discharged, but the BT would continue. And what for he will continue? He will continue for administration and distribution of estate. So first part is the resolution. In case the resolution fails, then the bankruptcy starts. In the bankruptcy part, there are again two parts. One is the first part where you the bankrupt and the BT, they will interact, understand the assets and liabilities, claims will be received, committee will be constituted, and then thereafter the bankrupt would be released and the BT will continue. This is the part that I want to share with you today, how the BT will continue and the bankrupt will be discharged. Now, see, if you see this, this is the duty of the BT to conduct administration and distribution and CoC meetings, and finally a report, and then the BT will be released after the administration and distribution. However, let us see now the discharge order. So this is under section 138 of the IBC. So this is a discharge order, which is a complete discharge order to bankrupt. The BT shall apply to adjudicating authority for a discharge order, and this is the duty of the BT to apply. When he has to apply? On 3 occasions. There are 3 situations where the BT shall apply to the AA. It is not may, it is shall. On the expiry of 1 year from the bankruptcy commencement date. This is the first event. On the expiry of 1 year from the bankruptcy commencement date, the BT shall apply to the adjudicating authority for a discharge order for the bankrupt. Second event, when within 7 days of the approval of the committee of creditors of the, if the administration and the distribution of the estate of the bankrupt finishes, if it finishes prior to 1 year, if the administration and distribution means that if all the assets are taken custody, all the assets are sold, and the distribution is made to the creditors, if all is done within, if it all is done less than, within a period of less than 1 year, then within 7 days of that particular event, the BT has to apply for the discharge order. Third event, BT can apply for an early discharge under Rule 9 if the assets are not sufficient to meet the cost of the process. Now, there may be various cases where, first of all, the insolvency resolution process have seen during the resolution process that there are no assets with the bankrupt. Then again, in the bankruptcy process, he has seen that there are no assets of the bankrupt. And third, he is also already seen that there is no further investigation is required in the affairs of the bankrupt. Then he can, again, under Rule 9, he can make an application to adjudicating authority for early discharge of the bankrupt. So these are the 3 events. However, nothing is beyond 1 year. Like if the first is if 1 year is achieved, second year is if the assets are sold and distributed before 1 year. If third is that in case he decides that there is no other asset, there is nothing which he can pursue. So therefore, everything is before 1 year. So the maximum period for which a person will continue to be bankrupt is 1 year. Maximum period for which a person will continue to be bankrupt is 1 year and not more than 1 year, and the BT shall apply to the adjudicating authority for a discharge order. That's a very, very important point that I wanted to make. So it is basically a boon for the individuals who are going through financial stress, who have given some guarantee to a loan to a corporate debtor, and they are presently struggling. They are being called as a defaulter. They are not able to do any business in their name. They are not able to protect their property. So all this is basically if this 1 year period. And then in the adjudicating authority shall pass the discharge order if satisfied, and a copy of that discharge order also should be given to the IBBI. That's a procedural issue. There are two, three now. Let's see the effect of the discharge under section 139. What is the effect of the discharge order which we have obtained from adjudicating authority under section 138? The discharge order shall release the bankrupt from all bankruptcy debts. From all bankruptcy debts, this order will release the bankrupt, except one, from the debt incurred by means of fraud or breach of trust to which the bankrupt was a party. So if he has actually taken a debt with fraud or with a breach of trust, that particular debt would not be the bankrupt would not be released from that debt. And of course, we have read the excluded debts, that if debt is a part of the excluded debt, then the bankrupt would not be released from the excluded debts.
That would be educational loans and
yes, Ankit, it is the
liability
loan
of maintenance.
Again, it is something which is a fine, damages, any debt taken with fraud or breach of trust, maintenance, education loan. These are the excluded debts. I mean, that is excluded from the purview of this act. So this Insolvency Act is not applicable to these debts. So we explained in our part 2 that there's something which is not a part of this law. Then the discharge will not affect functioning of the BT. Now, what I'm trying to say is that the bankrupt is discharged. Order under section 138 has been passed. He is released from all the debts. He is free to start business. He is free to become director. He is free to become a owner of properties. He is free from all commercial restrictions. However, the bankruptcy trustee is continuing as a professional, and he will continue to manage the operations of the business of the bankrupt, or he will actually handle the estate of the bankrupt. He will sell the estate. He will realize it, and he will administer it, and then finally he will distribute the proceeds. That is the job of the BT, and that will continue, and there is no such limit till what time it can continue. It all depends upon the committee of creditors, who finally will decide whether there are assets or not, and in case no asset, then it can be closed. So this is what is the most important part of the bankruptcy of individuals, where a discharge is given to the bankrupt within 1 year of commencement of bankruptcy date, and the BT will continue. So whenever we talk about the interest of our professional brothers, I would only advise that whenever you do bankruptcy assignments, you also must take care of some monthly fee, because in the individual bankruptcy, I will come to the fees. Today is very important that we will discuss the fee of the insolvency professional who will become BT. Okay, going forward, once this modification order is passed under section 138, the adjudicating authority has powers to recall or modify the bankruptcy order. Because see, once a discharge order is passed, he actually will be having a tag that he has been bankrupt for some time. He was bankrupt as on this date, and later on he might even become again a rich person. But yes, but there may be some people, they would say that I don't want to be called as a bankrupt, so I want to pay my debt. Now I have some source of income. So maybe after he may have some rethought, and he may try to repay, and then he can say that I don't want discharge, I'm trying to pay my debt. So there are two circumstances where the application can be made to adjudicating authority, or the adjudicating authority even can suo motu may recall or modify any bankruptcy order. And what are those circumstances? One, that the error is on the face of the order. If there is any error in the order or in the entire process, the adjudicating authority can take a call suo motu or on an application. Second, the bankruptcy debt and the expenses have been paid or provided for to the satisfaction of adjudicating authority. Now, maybe that's in some bankruptcy, there are circumstances that nobody files a claim. And even if there are no assets and nobody is filing a claim, and if there are small claims or some expenditures are to be paid, then person will say, okay, I'll better pay the expenditure and I'll completely get the bankruptcy would go over. So he will not get that discharge order. But then, because in case he doesn't get a discharge order, that means that he is not getting the complete, he is not getting the discharge from, he is not getting the release from the past debts. The other circumstances is that any sale or disposition of the property or payment made or other things duly done by the BT shall be valid except as decided by AA. So this is this clause provides that in case while this discharge order was passed or while this bankruptcy order was passed, any action taken by BT for acquisition of property, custody of the property, disposition of the property, or the distribution of the property shall be valid because that was done based on an order from the adjudicating authority. So any modification order has to be submitted to IBBI for entries, and that any recall or any modification order shall be binding on all the creditors as far as it relates to their debt. Now, coming to the insolvency professionals who are appointed as bankruptcy trustee as BT, I'm only handling one section 145, how the replacement of the BT can be done. CoC can replace the BT under section 125 with a vote of 75%, and it can be replaced with another BT. CoC will apply to adjudicating authority for replacement. The adjudicating authority, as usual, after verification of the credentials of the insolvency professional whose name is proposed, or they will see the information available with the adjudicating authority based on the panel which is prepared by the IBBI. So based on all this, the adjudicating authority will pass an order and the BT will be replaced. The earlier BT will deliver all the possession of the assets and everything of the bankrupt to the new BT. Earlier BT would be discharged under section 148 and he would not be continuing in the assignment. The new BT shall notify his appointment to the bankrupt within 7 days. So replacement, we have seen. Now we can see the resignation of the BT. Vacancy in the office of the BT. So there are 2-3 things. One is the resignation. And under 3 circumstances, the resignation can be accepted. He intends to cease practicing. B, there is a conflict of interest. C, there is a change of personal circumstances. Then the BT can apply for a resignation, and the adjudicating authority will pick up a person from the panel and will appoint a new BT. As far as the vacancy is concerned, vacancy can occur for any of the reasons other than above. Now, what are the reasons other than above? For example, due the maybe death of the BT. However, it is already clearly mentioned that the vacancy cannot be due to temporary illness or temporary leave of the BT. So there may be some situation that the BT would like to run away, because when the BT would understand that there is no asset, the BT might even try to run away, but that even the resignation is conditional and also the vacancy. So the temporary illness is not considered to be a valid vacancy. So that may not be accepted. Once the assignment is taken by insolvency professional as BT, I believe it would be required to complete it, or in case he's surrendering his license or some personal circumstances. So all that has to be fought. So this is this will be difficult to resign once the assignment is taken. The new BT would be appointed from the list of IPs, or because see, once this resignation or vacancy scenario, the CoC would not have any power to appoint or propose any name. The panel will pick up the name. This name will be picked up by the adjudicating authority. Now the bankruptcy trustee will deliver possession of the estate of the bankrupt to the newly appointed BT. The BT appointed will give notice of his appointment to CoC. Earlier BT shall be released. Now the BT would be released under two circumstances, because once section 148 is complete, the discharge of the BT, and will be released from his office, number one, in case the adjudicating authority appoints a new BT on account of resignation, replacement, or occurrence of vacancy. These are the three circumstances, so that he actually gets a discharge under section 148, or otherwise, if the CoC approves of the report of the BT under section 137, after completion of the administration of the bankruptcy process. So when he actually completes the administration and he completes the distribution, then he gets a discharge under section 148. Now talking the most important part as far as this insolvency professionals are concerned, fee of the bankruptcy trustee. Section 144 and also regulation 4. The fee of the liquidator as per the code should be based on the value of the assets of the bankrupt. As we have seen regulation 4, the number of the regulation is common, regulation 4 of the liquidation process, or the regulation 4 of the regulations on the bankruptcy of personal guarantors. All this is, the number is same, and also the provisions are almost same. It actually, regulation 4 provides that the fee of the liquidator and the manner it will be paid on fixed, and it will be decided by the committee of creditors. CoC can decide the fee as a monthly fee also, as well as a combination of monthly fee and success fee. That's out of my experience, because the law does not restrict. Regulation 4 will be applicable in case no decision has been taken. Otherwise, whatever decision has been taken by the committee of creditors, that would be final. The fee will be paid out of the proceeds of the assets of the bankrupt, and the regulation 4 provides that the fee would be paid as percentage of the assets realized and the amount distributed from such realization. And there is a schedule 1, which is almost similar to the schedule which is attached to regulation 4 of liquidation process regulations. However, there are two new rows which has been added, because the liquidation process, it starts at 1 crore of distribution and realization. However, in case of the individuals, it starts at 25 lakhs of the assets realization and distribution, and it also goes up to it also has another row of 50 lakhs, because see, in case we realize only 25 lakhs, I think the fee is about 10%. That's what I think. So this is what, Ankit, is the precursor to administration and distribution of the estate, because the administration and distribution of estate is a very large chapter. This is chapter 5 of the code, and this is very large because it actually talks about how the estate of the bankrupt would be handled. Various eventualities are being discussed, and everything is very important. So this we'll have, in case there is any question which comes in your mind.
So one question from Siddhartha Mukhopadhyay ji, he says, what is the time limit for distribution of assets in the case of a bankruptcy?
As I said, that I haven't seen any time limit, because even in the case of liquidation process, there is a time limit of 1 year, but every time we go for extension, the extensions are given. So therefore, in this case also, in this administration and distribution also, the time limit as such would not really mean. It only depends upon the actual work which is pending or actual work which has been done, and it all depends on the committee of creditors' decision and the BT's decision.
So sooner the better rule that we otherwise practically think is the rule in the case of liquidation because of the liquidator's fee structure. Is it similar here also?
Yeah, it is the similar as the liquidator's fee is there in the liquidation process. It is a similar structure.
So the sooner the better is would prevail that law.
Of course. So we'll just look into this, the chapter 5, and just a second. So in this chapter 5 of the code, which is these are the functions of the BT. So basically there are three functions of the BT. And that's one is the investigate the affairs of the bankrupt, and the second is realize the estate of the bankrupt, and the third is the distribute the estate of the bankrupt. The three basic functions of the BT. So most importantly, they investigate the affairs of the bankrupt. So this section 178 is important because this is similar to section 53 in the case of corporate insolvency resolution process or in the case of liquidation processes. Section 53 is used for CIRP and the liquidation processes. However, section 178 is used to decide priority of the payment of debts. Again, the similar priority, the first priority is the cost of bankruptcy process fee and the expenses. Second priority is having the pari passu of workman dues of 24 months and the debt owed to secured creditors in case they relinquish their security interest in favor of the estate of the bankrupt. The both will rank pari passu, similar to section 53. Then is the employees due of 12 months, again similar to the section 53. Then again, because see there is an unsecured financial creditor, that particular clause is not here. That clause is not here, and unsecured financial creditor, that will actually go at the last. That will go to the last. So the government dues for 2 years from the bankruptcy commencement date, that is also having fourth priority as against fifth in CIR in section 53. All operational creditor, unsecured creditor, anything which is more than 24 months of workman dues, anything which is more than 12 months of employees dues, anything which is more than 2 years of the government dues will all fall in the fifth priority. So anything, Ankit, you have in mind when we talk about the priority of debts and when we compare it with section 53 and now is section 178. So because unsecured has actually gone to the last, so there is no priority of financial unsecured creditors.
Right. So there is a change here. So one, the government is not the last. Then I believe there was no limit for government dues for 2 years in the case of CIRP.
No, that's there also. That's there in 53 also.
Okay, my bad.
And section 53 also has 2 years, and all 24 months, 12 months, 2 years is the same.
Yeah, 12 months and 24 months are the same. Yes.
Yeah.
All right. This is good. So let's proceed.
Let's go ahead.
Yeah. There are a few questions on the Q&A box.
Yeah, in case there is anything.
Harvinder ji is asking difference between workman dues and employee dues. So workmen and employees are both defined. So workmen, there's a definition by which workman dues are computed separately. That's the same in CIRP also. And who is so the other question from Chitranjan ji is, who is responsible, first BT or second BT, for the retention and production of records on demand for the duration before the BT is changed? Also, in case of change in BT, when does the first BT get his fees? So I believe if the BT, if there is money available, the BT can take his fee the way it happens today. Otherwise, the
Yes.
BT will be given that money as part of the cost by the second BT. With respect to the documents, I'm sure the documents have to be retained by the first BT for his tenure, and he needs to give a copy or allow a handover to the second BT.
Now,
That
I'll clarify this. As far as the documents are concerned, there are
mm,
two kinds of documents. One document which belongs to the bankrupt, and the other document is the other documents are which is uh, other documents are which is the so other documents are which is, and Ankit, I'll have to just pause for a moment. I'll just see what is the difficulty. So see, like as far as the section 178 is concerned, there are some other issues which are important to discuss, because as we have seen in section 53, there is no mention of priority of charges. And there is also no mention of the value of the security in trust. So there is only one line which says the secured creditors. It is not really having any bifurcation of the first charge holder, second charge holder, or subservient charge holder. It is also not having any clarity on who will get how much. In case a person has got a security of 50 crores and the other person has got a security of 5 crores, whereas both has got a claim of 100 each, who will get how much? Would they get proportionate to the debt, or would they get based on the value of their security interest? This clarity is also awaited in section 53, and the matter is presently before Supreme Court. And similarly, this matter again would be uh, pending in case of bankruptcy. In case of individuals, it will still be pending. So it is also clearly mentioned that in case of same subsection, in case different claimants are appearing in the same subsection, there will be equal ranking for all. For example, the workman, employees, or unsecured or operational creditor, all this would be the equal ranking would be there. Unsecured creditor shall rank equally amongst themselves unless they have agreed otherwise. So once this clause is there, so that actually means that agreed otherwise, that means that between unsecured creditors, there are provisions of first charge or second charge, because in case they would have any priority, that priority would be admissible as far as the unsecured creditors are concerned. But as far as the secured creditors are concerned, there is no mention in the provisions. However, we all will wait for the Supreme Court decision, as the Supreme Court has already given a decision in the case of Companies Act in 2005 in the case of Sidco Leathers versus ICICI, and has held that while the distribution would be done under winding up proceedings, the distribution would also consider priority of charges and the value of security interest. That would be considered. So we are in fact waiting for the similar judgment in the under IBC, and once this kind of judgment will come, then almost the same spirit will be applicable to individual insolvency also. So in this, there is another additional provision which says that the creditors can invest also in case there is any asset where there is some kind of deficiency in the charge, or some amount is required to be invested for getting full value of the asset, then the creditors can invest for protecting or for recovering the asset or for improving the title of the asset, and the adjudicating authority will order for an advantage over the others to that particular creditor who has invested. When the assets will be distributed, that particular creditor who has invested, that may get benefit. However, all depends upon the adjudicating authority. And one important change, one important difference between CIRP and here, in the case of bankruptcy, if the funds are available, even the interest can be paid to the bankrupts to the creditors if the assets are available. So these are all the distribution, the priority, various provisions regarding the distribution. Now I think we are going ahead for the duties of bankrupt towards the BT. The bankrupt has to do certain things, has to cooperate with the BT. And what are those duties under section 150? The bankrupt will give to the BT all the information about his affairs. The bankrupt will attend BT all times as required. The bankrupt will give notice to the BT within 7 days or any of the following events if occurred after the bankruptcy commencement date. Number one, in case the bankrupt acquires any further property, it will be informed to BT. In case any further property is devolved, on the bankrupt, it will be informed to BT within 7 days. Now, Ankit, the devolution of properties are, now suppose the bankruptcy starts and there are no assets. However, some devolution happens during the bankruptcy process, like the bankrupt gets some inherited property because of the any succession act. So that is called devolution, or on account of a will. So in anything which devolves on the bankrupt, the bankrupt will have to inform to BT within 7 days. In case there is any increase in the income of the bankrupt, that also will be informed to the BT. So the duties of the bankrupt would continue even after his discharge under section 138, except the clauses like as far as this. So this is very important. Even after getting the discharge under section 138, he will cooperate with the BT. He will also attend to BT. He will do other things as far as his estate is concerned. But after the discharge, if he acquires any property or if he gets any devolution or his income increases, that part he is not supposed to inform to BT. So the bankrupt is protected in case he acquires any property after the discharge order, in case he gets any property from inheritance after the discharge order, in case his income suddenly goes high after the discharge order, he is not supposed to inform anyone, including the bankruptcy trustee. So this is what is the protection, Ankit, to bankrupt, that after the discharge, he is not supposed to take care of old debts, even if his income or even if his assets goes up. Now, let's understand the rights of the BT. These are provided in section 151, and the BT can do all following things in his official name for the purpose of following his duties. He actually can hold properties of every description. He can make contracts, he can sue and he can be sued. He can enter into engagements in respect of the estate of the bankrupt. He can employ persons to assist him. He can execute any power of attorney, deed, or any instrument and do any other act which is necessary or expedient for the purpose of or in connection with the exercise of his rights. So this is what are the rights of the BT. The rights of the BT and the general powers are, these are all powers because the BT has to sell any part of the estate of the bankrupt. Then he can give receipts. He can even prove, rank, claim, or draw dividends in respect of such debts. See, where any property is held by any person as pledge or hypothecation, exercise the rights of redemption. He can exercise the rights of the redemption for such property, and the relevant contracts, and he can give notice. If the bankrupt has some securities in a company or any other property which is transferable in the books of a person, then he can even exercise the right to transfer the property, like transfer of shares, debentures, transfer of bonds, all that rights with the BT. He can deal with any property comprising in the estate of the bankrupt to which the bankrupt is beneficially entitled. Now, in case you see the BT in his official name, so what would be this scenario in case the person has got some shares? Then he can say the shares will be transferred. These shares will be transferred in the name of the estate of bankrupt, and the BT would be the signatory. This is the way. It is not like if the BT is Ankit Goel, so he cannot get the shares transferred in the name of Ankit Goel. He cannot get the property transferred in the name of Ankit Goel. He will actually get the property transferred in the name of the estate of Mr. So-and-so, and then he would be signatory in his capacity as BT. Now, we've seen the obligations and duties of the bankrupt. We have seen the rights of the BT. We have seen the powers of the BT. Now, let us see the powers of the committee of creditors. So there are certain acts which requires the approval of the committee of creditors, like if the bankrupt is doing any business, then the carrying on any business of the bankrupt as far as may be necessary for winding it up beneficially, because see, there may be some business which can be gradually wound up, or which will be closed gradually, or which even may have to be sold as going concern. So that is something which the CoC will monitor. In case the BT is supposed to bring, institute, or defend any legal action or proceeding relating to the property, that CoC approval is required. Accept as consideration for sale of any property a sum of money due at a future time. No, when this BT is selling a property and trying to sell a property on a contract where the money would be received in future and subject to certain stipulations such as security, and that also needs approval of the committee of creditors. And in case the BT is trying to mortgage, pledge any property for the purpose of raising money, and that also is required to be approved by the committee of creditors. Then, so there are circumstances where some payments are required to be made by the BT, which is for the benefit of the creditors, and there also because in case if there is any right, option, or other powers, like for example, like in case a bankrupt is entitled to say some options or some right shares or some asset where some investment is required to be made first. So that investment will be made by the BT. However, the approval from the committee of creditors would be required, because this is for the benefit of the creditors, because unless this investment is made, the value realization would be lower. Similarly, the CoC approval is required for any reference to arbitration or compromise of such terms as may be agreed. So any compromise which is required while the contracts are being pursued, or the contracts are being evaluated or realized. So any kind of compromise or other arrangement as he may deem expedient in respect of the claims arising out of or incidental to the bankrupt successed. Now, in all these cases, there are some things where the bankrupt also can be appointed by the BT. The bankrupt himself can be appointed by the BT, for example, supervising and management of the estate of the bankrupt for any part of it, carrying on the business of the bankrupt for the benefits of the creditors, or assist the BT in administering the estate of the bankrupt. So there may be some scenario where the committee thinks that the debtor is the more knowledgeable or more influential or would be able to handle it better, then the CoC can appoint bankrupt also for certain things like managing the estate or managing the business or assisting the bankruptcy trustee. So these are some of the very, very important things, Ankit, how to manage the bankruptcy, because as I said, this bankruptcy is a very vast law. It's not a small law. And we are now vesting of the estate of the bankrupt in the BT.
So one of the questions that is relevant here is that, of course, there are provisions that the bankrupt can be, made part of the process through that provision that we just read. But what if the bankrupt is not cooperating? Do we have any other choice other than going to DRT or NCLT the way we do that with CDs?
So that's the only option, like in case of no cooperation from the debtor or bankrupt. The only option is go to adjudicating authority and take directions from the adjudicating authority. That's the only option.
Yeah. Okay.
The estate of the bankrupt shall vest with bankruptcy trustee immediately from the date of his appointment. The vesting as above shall take effect without any conveyance, assignment, or transfer. So the BT virtually becomes the trustee owner, because the law says that no conveyance, assignment, or transfer is required. The BT will have all the powers to sell. The only thing is that the order is required that he is a BT. So that's what happened in the liquidation cases also. The owner is ABC and company and the liquidator is selling that. Now, as we have seen that the estate of the corporate debtor that we have seen section 36 of the liquidation of the IBC. So similarly, there is section 155, which defines the estate of bankrupt. Now, what is included in the estate of bankrupt is, number one, all property belonging to or vested with the bankrupt on bankruptcy commencement date. Second, all rights of bankrupt in respect of any property which can be exercised by the bankrupt as on bankruptcy commencement date or before the date of the discharge. So by this is like before, as on the date of BCD or before the date of say discharge, that means any property which even devolves, any property is acquired. So these are all the rights that can be exercised by the bankrupt. As I said, then these kind of rights can be rights to apply for the options, rights to apply for the right issue, rights to apply for various claims or contingent assets. So all these are part of the estate of the bankrupt. All property by virtue of any provisions of this chapter. Now the estate of the bankrupt shall not include. So I think the estate of the bankrupt, what it includes is almost very vast. It includes everything. What it does not include is, first of all, excluded assets that we've already said, any tools, any vehicles which are necessary for the living or for his occupation, a residential house worth 10 lakhs, the jewelry which is for religious purposes, which is about having a maximum value of 1 lakh. All this is excluded assets. So those excluded assets are not part of the estate of the bankrupt. Then the property held by the bankrupt under trust for any other person. This is also similar to section 36 for companies. And the other clause, all sum dues to workman and employee from the provident fund, the pension fund, and the gratuity fund. This is also very well clarified now by Honorable Supreme Court in the case of Sunil Kumar Jain versus Sundaresh Bhatt. So that the provident fund, pension fund, gratuity fund is, in case there is any fund available, that will be outside the estate of the bankrupt. But in case there is no money in these funds, it is not the duty of the liquidator or it is not the duty of the BT to fill these funds from other money. So these are the issue of estate. These are something which are the estate we've seen. Now, I think this after section 155, now we reach out to section 156, which talks about the enforcement or the rights of the BT, how to take over the properties or how the everyone is responsible to deliver the property to the BT. So it says section 156 says that all the properties or documents would be delivered to the BT. So who are responsible? Number one, the bankrupt. Number two, the bankers. Number three, the agents or any other person. They are all responsible who are having any possession, who are in possession of any property of the bankrupt, which may be a property, which may be books, papers, or other records, shall deliver the possession to the bankruptcy trustee. So they will, like the bankrupt, the bankers, and the agents, they will deliver the possession to the bank BT. So these are the enforcement. In case not done, then there are options available with the BT. Next is acquisition of control by BT. BT to take possession of all the property, that is provided under section 5157, that the BT has all the powers to take possession of all the properties, books, papers, or other records relating to the estate or affairs of the bankrupt from his possession and control. So BT will take the possession from bankrupt or from bankers or from the agents. All the control will be taken by the BT. All actionable claims shall be deemed as assigned to BT without any notice of assignment. Now, in case there is some actionable claims, like I may have an insurance claim, as the bankrupt may have a claim on the family for some properties. The bankrupt may have claim from a employer where he was employee earlier. The bankrupt may have claim against any contract that he signed. So all these actionable claims will be assigned to BT for the purpose of further actions to be taken.
So there are a few questions here.
This is something which is now we are moving to the restriction on disposal of positions, and I think we can take some questions.
So one question is that the bankrupt estate or the estate of the bankrupt is a paper entity. So I don't think there's any registration required as a society or anything. The way we are currently, we say dash company under CIRP or under liquidation rather. So that's how the account will be opened, and that will be the entity which will be basically the bank account will be opened in that manner. So no registration required anywhere. There is no legal status of this entity per se. Don't think it can be called a society or anything like that.
You're right, absolutely right, Ankit, because this estate of bankrupt is a legal status. It doesn't require any registration. It is an automatic status. It comes out of the order of the adjudicating authority for bankruptcy process.
There's another question that at the time of giving the guarantee, somebody had given a net worth statement of 50 crore rupees. At the time of application to exercise the guarantee, that was reduced to 5 crore rupees. So I think this is only about look back period. This is where it is very, very important for all the creditors to be alert that if somebody is selling their personal properties, then one should act quickly rather than late. That really helps in increasing the recovery process.
You're absolutely right, Ankit. There are provisions like the undervalued transactions or preferential transactions. So in case
but practically speaking, there in a place like India, when you have most properties having a dual pricing, you can never say what was the price at which it was really sold. So it is a very difficult scenario. The idea is to catch the defaulters at their first default for the creditors to realize the maximum possible money.
So there are two things, Ankit. One is that the creditors, they are supposed to take a faster action for appropriate recovery. But as far as these humans, like individuals, are concerned, they also can get away in case they take these actions of like bankruptcy or insolvency resolution process on time, so they don't suffer for longer period. So they can actually bring all this to halt in case they take the shelter into the insolvency resolution and bankruptcy, and they can even restart, they can reset their commercial life, and they can again be
Yeah,
again be.
so that's from the bankruptcy trustee point of view, and from the creditor's point of view, the idea is to start early, to begin early at the time of default itself, because there is no action that can be kept pending. If somebody says that okay, there's a default, one can start action against the CD and the guarantor at the same time. There is no need to for somebody to wait for a CRP and then start the process or so on.
Right, Ankit. If there is any other question, otherwise, because if the time is again up, we are not
Yeah.
sure whether we'll be, because there are a lot of things, because we have to address to the avoidance transactions, we have to address to the prosecutions for giving wrong statements. All these precautions are very, very important. However, we'll take up, because this is only about 3 months, 4 minutes, and we'll handle this part, this section 53. You may recall that we have said that there will be a moratorium. There will be a moratorium from the date of application. However, we have not seen any line there where the disposal of the property was restricted. But when we see this section 158, we've seen that the restrictions on disposition of property, any property disposed between the date of application for bankruptcy. Because see, when we saw that, we have seen that that was the moratorium for insolvency resolution process. This is a moratorium for the bankruptcy process. So when we file an application, there is no restriction on the sale of assets. However, when we file the application for bankruptcy, there is a restriction on the sale of assets by the bankrupt. So in case any asset is sold between the date of application for bankruptcy and the date of commencement, that would be void. So any such disposal by the debtor shall not give any right to any other person. However, like in case, there is a further question, in case the bankrupt sells the properties after filing the application. So there is no right which actually can be created against the third party in case he has bought it in good faith and he has bought it for value received and without any notice of filing of the application. So the buyer, he is protected in case the bankrupt sells any property, and in case these three conditions are fulfilled, then the buyer is protected. Property includes all property of the debtor, even if it does not form part of the bankruptcy estate, but not to include property held under trust for any other person. Now, Ankit, if you just try to understand this, these are now the most difficult parts of the bankruptcy: after acquired property, onerous property, then the disclaiming some of the properties, then there is disclaimer of leasehold properties, and then we have this undervalued transactions, and then we have preferential transactions, and then we have extortional credit transactions, and then we have obligations under contracts. Then in case there is a death of the bankrupt, because see, like there has been a case in NCLT that if the grantor is dead, then no process can be started. However, this particular section says that in case the bankrupt dies, the proceedings shall continue as he is alive, and all the
so death has to. So in this section also, the death has to occur after the process has started. It seems so.
Let's see, because it's not if the bankruptcy process shall continue, because this is something that we'll see. Distribution also, the distribution of property, final dividend, and then the most important part is realization of asset. How the assets will be realized. Valuation is also to be covered. The bank account, how the bank account, bankruptcy cost, registers, reports. There is so much of in the bankruptcy, and then finally we also have this how to sell. And then finally the prosecutions that we have covered in the other part. There are a lot of prosecution sections. So we have already finished this part. So we will.
So I believe we are out of time now. So I think we have to take this part next time. Do you think that we will be taking up another topic along with this left out part in the next?
No, I think this particular part is very important. So it will take 1 hour. It will take 1 hour. So we will do it on 22nd. And this 22nd, which is Sunday at 4 p.m. So we are trying our best to explain all possible like we have done that So now we have this various kinds of properties, because unless we know the law, it is very difficult to give any consultancy to any person who is under financial stress. Because see, like the chapters that we are now coming, these are the chapters which actually will have impact. And unless we know this, it will be very difficult to provide consultancy to persons under financial stress. So Ankit, we can stop here and we'll start from after acquired property in the next Sunday at 4 p.m. So because this is a vast subject, and this is going to stay in India as bankruptcy law. So we need to cover it in detailed manner. So
Great.
over to you.
So thank you, everyone. Thank you so much for being part of today's session and today's, I would say, 1 hour that we spent with each other. Thank you for the participants who asked the questions. Looking forward to see you next Sunday. Thank you.
Thank you very much.
Thank you so much.
It's a pleasure for us, and it's our way of learning. Thank you.